Most people desire to direct where their assets will go following death. Perhaps it's their loved ones, their family. Maybe it's a favorite charity or their church. However, most people assume that the last will and testament is the document that's going to control where those assets will go. Historically, that was always the case, but recently there's been a variety of vehicles that have developed which allow assets to pass outside of probate. So now let's look at the different ways that assets can pass when a person passes away. The first way that assets will pass is through contract. And before you fall asleep with all the legalese, what's a contract? What's a popular type of contract? Well, think beneficiary designations or trusts. Most of you, when filling out your retirement paperwork or life insurance paperwork, are asked to provide a beneficiary. You fill out the beneficiary designation. That is the contract that you have with the insurance company or your financial institution as to who is going to receive those assets when you pass away. The second way that assets pass at death is through operation of law. Operation of law sounds very legalistic, but what does it mean? It's really co-ownership with survivorship rights. The most common examples are bank accounts. Often those are set up joint with rights of survivorship, or maybe real estate, which is also commonly set up as joint with rights of survivorship. What that simply means is when one co-owner passes away, the ownership will automatically pass to the surviving owner. The last way that assets pass at death is through probate. Probate is really the catch-all for all those assets that don't pass outside of probate through operation of law or beneficiary designations and contracts that I discussed earlier. Probate is for those assets that are in your name individually with no beneficiary designated. For those assets, a probate estate is opened in your local probate court, and your last will and testament is admitted to the probate court. What's the last will and testament? It's basically the instructions to the court and the executor of your estate as to who will receive those assets. The important thing to understand, though, is the last will and testament is only going to control the distribution of the assets in your probate estate. It has no bearing on those assets passing outside of probate through beneficiary designations or survivorship rights and co-ownership.